Hello everyone. We forgot to start recording in the beginning of the webinar. Apologies for that. However, I can assure you that we have captured the rest of it. So enjoy.
Helps you to manage like your financial world in a single platform and able to have more meaningful conversations within the family as well. So it helps you to prepare for emergencies where one person who has been managing everything, if something happens to that, family still have got all the information, they have got access to that information, which is very important, right? To tell about MP Estate, where Mike is the founder of that. So they specialize in bespoke estate planning solutions to protect your assets, minimizing your taxes, and securing family legacies, right? So we help you with the information bit. They actually do all the legal part as well. They help you with like managing, and because every family situation is quite different, so they actually do a very customized like solutions and planning for you. They've got a dedicated team of experts, and they offer the MP Estate protection plan tailored to each client's needs. And they are renowned for their excellence and up-to-date experience, expertise. And they ensures like a peace of mind by delivering reliable, personalized support every step of the way. Yep. And over to you, Mike.
Hi, good morning, everybody. Thanks for taking time out of your day. Yeah, I didn't know there were so many Death and Taxes fans, but happy to make and certainly very grateful, Varun, for inviting me onto this call. Happy to spend some time with you all. My name is Mike Pugh, and I'm a tax lawyer specializing in estate planning here in the UK. I basically specialize in all the stuff that we know we need, and frankly, nobody really wants, because who wants this stuff? What I want is 20 more years of life, just like the rest of us. But the fact is that at some point, the sand is going to run through the hourglass, and then you're not going to need your stuff. And so who are you going to leave all your worldly assets to? By definition, people on this call are generally going to be successful or high net worth or proactive, at least in their view on things. So happy to have this conversation. What is estate planning? Why does it matter? It matters a great deal because in this, I don't know if anybody saw the budget that came down 2 weeks ago, but in this world we live in, and I'm 57, so the world's changed radically in the course of my life. But we need to secure, if you spent the first half of your life trying to acquire assets, which almost everybody on this call has, because that's the very innate built-in function of us. In the second half of your life, acquisition becomes a little less the focus, and maybe enjoying your assets. And of course, your mind starts to turn to, how do we protect some of this stuff? Because you busted your tail, or you grafted, to speak English, to get what you've got. And therefore, we need to actually put some legal remedies in place to stop all this money from going sideways. What that can give you is absolute peace of mind. I literally just got off a client call with another client we're just finished completion, and he's giving me a video testimonial. So you can't be any more authentic than people saying that, yeah, there's a legitimate peace of mind element, knowing that if you've had good fortune, you've made a lot of good decisions, you've grafted very hard, and you now have some assets, then would it be a bad idea to put some protections in place so you just don't lose all your wealth? Let's go to the next slide. If it helps at all, we are the anti-risk guys. I sound like a sales guy because that's my classical training before I got into law and taxes, but the fact of the matter is I'm anti-risk. I'm not the make more money guy. I'm the don't lose all your money guy, if that makes any difference, if that helps you to understand what my role is. I've also got 2 kids. One's in university, the other's in 6th form, and not interested in problems. So the key documents that comprise an estate plan are very simply a will, a lasting power, and a tax or plan and a trust plan. Talking about inheritance tax planning, for the record, I deal with 3 taxes. I deal with inheritance taxes, capital gains taxes, and income taxes in relation to trust planning. I'm not going to file your self-assessment. I'm not going to do your VAT returns. That's not what I do. I'm not an accountant. So what we're going to do is be able to wrap a legal framework around the assets that you presently own, because we can't deal with stuff you don't own. That's, no one's going to put the Eiffel Tower into a trust with me. That's not a thing. As far as wills goes, everybody knows what a will is. For more or less, it's a device designed to get assets in direction. If you're unfamiliar with lasting power of attorney, then welcome to this call. An LPA, or a lasting power of attorney, is a key document that's going to allow the people you love and trust to be able to make decisions on your behalf while you're still alive. So how does that work? 20 seconds on this. We don't know how the end game's going to go. Maybe we remain sharp as a tack, but the legs stop working. Or maybe we go to the cracker factory, we lose mental capacity, but the legs work just fine. So now we're wandering the streets. You're going to need people that you love and trust to be able to look out for your interests while you're still alive towards the end of life. And this can go so far as to helping keep mom and dad in their homes and out of a care home. There's all kinds of utility to these documents. They're critically important, and sadly, the inception rate on this is very low. Maybe 25% of people will have their lasting power of attorney. And then everybody's come onto this call because of the trusts and tax planning element, presumptively, because the wills in an LPA is just the bog standard baseline for anything that you're going to do, whether you work with us or you work with others. It doesn't matter. Tax and trust planning has always got to be designed around what you currently have and where you want to get to. The little picture on the screen here is we used the Kessler 15th edition, James Kessler KC. I've actually had emails with him allowing me to use precedents. He's a lovely man. He's the #1 guy for taxes and trust worldwide, period. I'll just throw a shout out to my mentor, Dr. Paul Hutchinson, whom I've worked closely with for 10 years. Paul trained under Kessler for 20 years. So we're pretty comfortable with technical capabilities. Let's go to the next slide, Brian. What are the benefits of trust? Well, clearly taxes and care fees are the top two on everybody's list. I don't know if anybody noticed, the very first thing the Labor government did when they came into government is they removed that cap on care fees. So regardless of how much wealth you've got, losing control of it is anathema. That's the opposite of what you want to do. You want to hold on to the control elements, or at least have people you love and trust in control of your assets. And that can help to defeat care fees. And inheritance tax planning is a bit of a tax thing we can do with trusts. It's certainly no problem. Trusts have been available here in England for over 800 years. There's nothing new about this stuff. The only thing new is the internet. Now what used to be sacred knowledge that was held by the local town solicitor, everybody can get access to this stuff. So you don't need to believe about trusts. They've been around. And if you go into the public record, you'll notice that all the senior politicos have trusts, all of them. In fact, I do have clients who sit in the House of Lords and clients in the House of Commons. I've got celebrity clients. Trusts have been around actually for as long as 3,000 years. You want to go back to reading the Iliad under Homer. So they're not new. And basically what that means is people are now getting the ability to learn more about this stuff, learn about what we would call maybe the big secret, maybe what has been known by the wealthy in this country, certainly for generations. This is why you get families of exceptional wealth. Because rule #1 about estate management is do not lose the money. You can do a lot of mistakes in this life, but if you don't lose the money, you still got it. So it doesn't matter what your rate of return is, even if it was 1%. Let's go to the next slide. You can build a legacy through estate planning, because as long as nobody loses the money, it really doesn't even matter where your ROI on this is or rate of return, because you just continue to acquire assets. And so you can do generational wealth. And this is a huge deal, because some of the wealthiest families have, it's not that they have smarter stockbrokers in the market. That doesn't matter. You might be very good at buying and selling properties. Excellent. But if you've got to give 40% of that away when you die, after 3 generations, it's all gone. So don't lose the money. Rule #1. Then now you create generational wealth and legacy. And that makes a big difference. Because either after 3 generations, your money is still in the family, or it's basically all gone, if that makes sense. So that's what we're up against. And most people understand that they need a will, but a will isn't going to give you the types of protections that a proper estate planning will. Full stop. A will is a great distribution device. Let's go to the next slide. So structuring a tax efficient plan, it's really important that we understand that when we do a client interview and we try to understand, the first thing we always ask clients is, what is the problem you're trying to solve? Because I get a lot of folks coming to me for divorce advice. I'm not a divorce solicitor. I don't deal in family law. I get some people coming to me for insolvency advice. I'm not a bankruptcy expert. I don't do insolvency practitioner. I'm not none of that. I'm in a very narrow niche, state law. I'm just incredibly deep in my niche, and we've got our bona fides intact with a doctor of law and Kessler behind us. So we all agree basically that we need to pay taxes, because I'm also not an anarchist. And after living in Canada where I grew up and living here, I like the fact that our services to a greater or lesser degree work. And we can have a longer conversation about that. But the comment I had with a client last Friday was, boy, I don't like the government wasting my money. And the answer is no, nobody does. But at least in this country, they're honest about the fact they're screwing up with your money. Whereas in other countries, they just try to grab all your money and shove it in their pockets. So I don't know if that helps anybody, but if it gives you any mental relief, at least they're honestly dumb about the way they spend our money. They're just not out and out stealing it like they are in other countries. So this is a pretty good place to be. I'm not an anarchist. Pay your tax. But inheritance tax is one tax that is a tax on pre-tax assets. So I pay my council taxes, my VAT, my consumption taxes, my income taxes, like you do. And then at the end of my life, the government getting 40% of everything I've made and earned and sweat is kind of the opposite of what I want. So it's a tax on pre-tax wealth, and it just doesn't sit well. And so we don't want to leave the government almost half of everything we've worked so hard to have over the course of our lives. Let's go to the next slide. So some additional tips to protect your home in the face of current UK challenges. Well, the face of the current UK challenge came down to us on the 30th of October, didn't it? If you own a number of properties or even have a pension, yikes. And I'm not saying that to scare anybody. It literally caught all of us, caught our breath, because Labour government, I'm not trying to diminish the government. It doesn't matter who the current sitting government is. Just the governments, by definition, are going to always be hungry for more revenue. That's just the way it works. Well, when they came after the pensions, which are now going to be in everybody's inheritance tax thresholds after April 27, if you've read the budget, and as long as you've got a defined contribution scheme, which most people have, then that's going to fall into inheritance tax planning, which we can help to talk about. If it's a defined benefit scheme, which less and less people have, but strangely, all the government employees have those, or most. See what they've done. They've protected anyway. Those guys are not going to fall victim of inheritance tax planning. So we've got to stay current and congruent with the ecosphere that we're in. One thing to take away from this is that trusts and tax planning is not a fire and forget missile. This is not a silver bullet that one thing does everything. The world we live in is much more complicated than the world I grew up in. You know, as a kid, I didn't have a mobile phone because it didn't exist. Today, everybody got mobile phones, everybody's got PCs. The world's changed radically in the last 50 years, sincerely. So you got to stay on top of this stuff, which means you probably need to review your estate plan every 3 to 5 years. It's not an annual thing. It shouldn't cost you any money, really. It's just a matter of staying on top of the current situation. Between rising mortgage rates, fluctuating housing prices, and economic pressures, I can only guarantee you one thing. The government is going to continue to come after people looking for more money in the future. And I'll err for 10 seconds into demographics. Everybody on this call, I'm guessing, is somewhere over the age of 30. That's a pretty reasonable guess. The biggest cohort of people in this population in the UK at present is the 50 to 60-year-olds. That's the largest single cohort. You can Google all this stuff. Just Google demographics UK, and you'll get the Wikipedia page. You'll get all the data. And if you have a close look at it, you can see the largest single cohort. And where is the money? Well, the money's always with the older generation because they've already paid off their homes. The kids have probably left home. They've got higher disposable income. So this is the absolute target market they're going to come after. And as this ages, who are the people that can least defend themselves? And it's generally the elderly. So you have to be cognizant of where you are now and where you are going over the next 10 and 15 and 20 years so you can stay on top of these things. So I guarantee you one thing, the government will not shed a tear when you fall off your perch, right? They're just going to ask for the money, please. Let's go to the next slide. So a couple of things for you to take in. I understand this to be about a 30-odd minute webinar. I'm happy to take calls and questions, no problem. Some other things for you to think about as you want to stay on top of your mortgage, make sure that's working. You want to make sure you actually have key legal documents in place. Everybody kind of knows that. And I'm the same as everybody else here. Why do today what I can put off till tomorrow? I get that. The trouble is, it is generally agreeable that no one knows the future. And nobody really knows when the bad things are coming. And in my line of work, estate planning, not estate panicking, you need to do this stuff years in advance of problems. If everybody gets confused about the 7-year inheritance tax taper relief, But that's common. So let's just say you need to do this 7 to 10 years before bad stuff comes along. That's an easy one. And then we very probably can make you bulletproof. You might want to set some financial alerts. If your estate you win the lottery, remember, it's always a good idea to give half of it to your favorite British Canadian estate planner. That's a joke. But the point is, people's financial situations change. Maybe things have gone very well and you need now to put some other planning in place. And the final bit here on this slide is very, very important. Just talk with the kids. They're not dumb. They understand that if you've acquired some assets, they have a reasonable expectation of seeing some of them. I often ask every client as we get to the end of a process to make sure the kids attend 1 or 2 of the meetings, so that way they can know a little bit of what mom and dad are putting in place. The last thing we need is, what are the 3 leading causes of death? Fire, panic, and confusion, right? Let's avoid all that. Let's just have some kind of transparent conversation with the kids around what mom and dad are doing. If possible, some families are a little very cloistered on that type of conversation. I look at it like this, and I'll leave you this one thought. A lot of people look at the work that I do as, oh, I don't want to do that. That's about death. I don't want to think about that. Yeah, well, fair on you. That's fine. The view that I had from another client just on Friday last week, he said, Mike, I don't look at this like it's a pain point or a problem. I look at it like it's love. Caught me off guard. And I said, how so? I said, well, I've worked hard and I love my family, and I want to make sure that what actually gets to them is what I've worked so hard to have. And through the good fortune and a number of decent decisions, I've arrived at here. So now I just want to put a wrapper around things and make sure it's all going to stay squared off for them. I thought, hey, that was pretty good. Hard to say that it's love, but at the end, because really it's money. But at the end of the story, if you do love your family, if you do think that, or whomever it is that you love, if you want to make this thing happen, and remember, you don't have to leave assets to family. If you want to leave assets outside of the family, trusts are exceptional at doing that. More importantly, the very, very last thought, technical thought, is trust can eliminate contention. So if you think people are going to be wanting to lawyer up and sue people, I had coffee with a contentious probate solicitor this morning. The nice thing about a properly structured estate plan is it can reduce the possible contention to literally nil. It just shuts that out. Right. Next slide is the wrap, I guess. How did I do, Varun? Did I cover kind of how was that? Was that helpful to anyone?
Yes, no, it was absolutely gem. Like, it was pretty good. And one of the things like I would like to add over here, like, which he said that, don't lose the money, right? Because yes, like you have worked throughout your life, building wealth. And if you are not able to preserve that, then what's the point of, like slogging the whole life, right? So which is why the estate planning is one of the very important aspect of the building wealth as well. And a lot of times, like, people think about these as a very later stage thing as well, which is it's not, because you need to start thinking the moment you start building wealth, as like Mike mentioned as well. And which is where that, like, part of that, like what we are doing, like Know Your Dosh, that, like we help families to bring up those conversations as well and help you track your like wealth as well in a single platform. So you can share that information with your family members so that they are aware. And that, as rightly Mike said, right, you need to involve your family in your financial decisions as you're doing on your own, because like it's very important. Otherwise that, like they are at the losing end, right? So we'll like open the floor for question and answers. I think like we have got quite a few in chat. So let's go through that.
Yeah, we've got one here from Rajesh. Can your pension still be put into a trust and not subject to inheritance tax? I know that the new bill may change some of the current laws, so I thought will be a good topic to cover on this, Mike.
Yeah, that's a great question. So just to be clear, I'm not a financial advisor. I'm not regulated by the FCA, and none of what I do or our firm does is considered financial advice. We're tax guys. So the answer to your question, however, anything that can be owned can be placed into a trust. And previously, by definition, a pension was always considered to be part of a trust, and therefore outside the reach of HMRC for inheritance taxes, right? But what they've stated now is that if you have a defined contributions pension after April of 27, that's going to be inside of your estate for inheritance tax purposes. Now, these are still fairly early days, and there's a number of consultations that are ongoing. And right now, the hue and cry in the press is about agricultural relief being removed if you're catching all the farmers outside of Westminster. But the pensions thing's even bigger because it affects more of us. So the short answer to your question is yes, you can put a pension into a trust. And yes, that might be, you might be able to come up with a mechanism there where we could remove that from the reach of HMRC for inheritance taxes, but then that would need to be settler excluded. So if you were setting up the trust, you would no longer be benefiting from that pension. And so you can see the problem already, the friction in there. So there is no well-defined answer to that question right now because it's been so recent. We're 21 days since the budget has arrived, and the government's still going through a consultative process around this stuff. Does that help? Because yes, you can, anything that can be owned can be placed into a trust. So gold bullion, for example, we can't place into a trust. Jewelry, we can't place into a trust. But boats, cars, planes, bank accounts, pension accounts, all that can all be placed into a trust if it can be owned. How did I do?
That's excellent. Yeah, that's excellent. I've got another question here. What if you don't have your own kids but want to leave assets split between your spouse, stepchildren, nieces, and nephews?
Perfect. So the answer is we can absolutely do that. You can absolutely do that both in a will, if the estate is below the tax thresholds, you're not worried about the tax issues. But then you still got to worry about the care fees problems because care, whether or not you have a tax problem, care will, if you don't have a tax problem, sadly, care will normally wipe out the estate. But answering your question specifically, if you have an unequal distribution to non-lineal descendants, to not your blood children, you can absolutely do that within a trust framework, easy as pie. You could also do that within a will framework. The benefit of the trust over the will is, well, will distribute assets. A trust can actually give you protections while you're alive. And respectfully, most people's problems occur while they're alive. Very few people have reported back to me explaining they have problems after they're dead. That was comedy. I don't know if that makes any sense, but I've heard too many clients of mine who've died and that said they had more problems. So the goal is to protect yourself while you remain alive. And then trusts are fantastic at distributing assets.
That's excellent. Thank you, Mike. This is quite a basic one, but I think a few people were kind of unsure about it. So what would be the best way to make sure that you are securing your home for your children against, for instance, care fees?
Okay, so the care fees thing is, there's a lot of misinformation and confusion on the internet. If you really want to go snowblind, as a Canadian reference, start Googling stuff. It'll make you crazy. But the bottom line is, you need to do this stuff well in advance of care, because and you probably need to speak to a specialist who understands what they're doing in relation to trusts, because what it boils down to, what is the value of that home? Because most people's largest asset is their main residence. And so you want to get that protected from care. Again, problems come while you're alive, not after you're dead. And then if we can do the tax planning off, if this estate is over the thresholds, then we do some tax planning as well. That's not a problem. And so the answer to the question is, speak with a knowledgeable estate planning professional. Of course, we're available. You're welcome to come and speak with us. But a basic will writer is probably not going to be able to get that done for you. And that's no diminishment. Everybody has to start somewhere. You probably need something a little more robust than just a will.
Thank you, Mike. That was excellent. I hear a few people asking about the costs. Our price list is published on our website. We also have a video on the cost of everything as well on our YouTube channel. So you're more than welcome to have a look into our website, mpestateplanning.uk, and everything should be there. A few questions as well around costs and ongoing costs. Mike, can you expand on that?
Yeah, so thanks. Cost is important. Nobody, I'll do the same thing everybody else on this call will do. I'll drive half a mile to save 2 gallons petrol, right? Why wouldn't you? I think we're one of the only companies, sincerely, or certainly we were the first, that has a highly detailed price list available on our website. So we're not at all shy about price. We're completely transparent. People love that. When they come back to me and tell me they appreciate it, because getting a price out of a solicitor's firm is well nigh impossible. And so the idea is you can compare it, and I'll also show a little video on YouTube. Ongoing costs should be, in the vast majority of trusts I've advised on, the ongoing cost is nil. I didn't stutter. Here's why. You're the owner of the asset, presumptively, and so is your spouse. So we would recommend you and your spouse remain as trustees within the framework. You can go ahead, Varun, and advance to the Stay Connected page, and people can get the data if they want it. But the idea behind it is, if you own a thing, I don't want you to not own it any further. For the record, we don't take custody of assets. That's not the way this works. At no point do you release or reduce control, or shouldn't. We want you and your spouse and or adult children or people you trust to be the trustees, therefore the people in control. And because your family and friends are non-professional trustees, no one's charging any annual fees. There should be no annual fees to this stuff. So the short answer here is the run cost on this should be zero. If we're just dealing with a main residence, the run cost should be zero. If you're dealing with buy-to-lets, then we're getting into a separate piece of planning, different tax frameworks, because there's income. And then we can reduce income taxes around that depending on, your situation. But certainly for mom and pop putting their house into a trust, the run cost is nil. Back to you, Alexa.
Oh, excellent. Thank you, Mike. There's a few people as well asking about multiple properties across different countries in one trust.
Okay, so that's going to be a problem. If you're fortunate enough to own property in Spain or Portugal or any one of these lovely places where it's warm and sunny, and we all aspire to live, or at least vacation often, putting overseas assets into a UK trust makes that an offshore trust, and therefore this is now going to have an entirely different and far more complicated tax regime. Our advice ends at the shoreline, meaning we cover assets based in England and Wales. And whenever a client comes to me with properties in Spain, and a lot do, I ask them very simply, are you intending to hold this through your passing? Do you intend to hold on to this asset in Italy or this asset in this foreign country? Because if you do, remember, we are client side. We're very much on the client side on this. You may very well wish to speak with an estate planning practitioner in that jurisdiction because, for example, a lot of the Islamic countries do not recognize trust law. But they will have other mechanisms within these jurisdictions where they can protect and resolve legacy planning. So if your intention is absolutely to hold on to that piece of land in the mother country that you came from, that's cool, get it. Then maybe you want to speak to somebody in that country about those assets, and we'll deal with everything that's onshore. What we don't want to do is we don't want the trust to become an offshore trust and then be subject to those tax regimes, because that's a bit onerous. That's the answer.
Cool. Thank you. There is a couple other that I think that would be good to go through. Can you put a second home, like holiday home, city flats, into a trust?
Great question. So the answer to can you put a second property into a trust is yes. Again, anything that can be owned can be placed in a trust, excepting that, allow me to explain it like this. Let's say you have only one property. Well, clearly there's only going to be one tax and trust solution. But where you have two or more properties, maybe you have 2 properties, maybe you have 51 properties. Well, the other 50 or one property, anything that's not your main residence needs to be in a separate piece of tax and trust planning. And this is not our efforts to try and sell our services twice. The reason is very simple, and you'll get this instantly. How much capital gains tax do we pay on our main residence? The answer is nothing, as we all get the Section 223 relief, don't we? And how much residential no rate band do we get on our main residence? The answer is £175,000 per co-owner. So if you're a married couple and you own a home, you get £350,000 of tax relief. None of that exists on the buy-to-lets. So that's going to be a completely separate piece of planning, tax and trust-wise. You cannot commingle all the assets into one trust, which often people say, why can't I do that? Well, because then you're going to end up paying stamp duty and capital gains on your main residence, and then you can be upset with us. And let's just agree that that's just suboptimal. That's not smart, no matter what. No matter who you deal with, You should never be placing your main residence and your buy-to-lets into the same trust. That's just crazy. That's insane. So if the people you're speaking to don't quite understand that, you might want to ask them, what do you do about the capital gains? Because you're going to trigger a capital gain event if you get poor level advice. That's
Thank you, Mike. Mandeep also has her hand in the air, and she actually raised a question as well on the chat. So, can legally owned properties be put into a trust, and can they be challenged?
So the answer to that is yes, legally owned properties can be placed in a trust. And there's two types of placing them. So let's talk about how to place properties into a trust. There's two possibilities there. And then can they be challenged? The answer is yes, they can be challenged, because I'll deal with the can be challenged thing. Yes, there are solicitors out there that will take your money and will challenge anything you want. There are ambulance chasers that will take your money. No problem. Doesn't mean they're going to win, but they could give you a bit of heartache if who wants a lawsuit? Doesn't mean they're going to win. It just means somebody lawyered up and decided to start firing off in all directions, and that's fine. People have humans are allowed to make choices, even if they're crap choices. Excuse my language, but we can't stop people from wanting to go contentious if they want to, but we can stop them from winning. And I'm delighted to report that after 12 years, we've not yet lost, because we just do everything sufficiently in advance. Coming back around to can we put properties into a trust? Yes, there's two ways to do that. First of all, do you have a mortgage on the property? The answer is 60% of us have mortgage on property, because that's how people own property. So what we put into the trust then is not the legal title, but the beneficial interest. Remember, your name is on the title deed. You own the property. You own 100% of the legal title of this property, but you don't own all the money in the value, because you have to pay this mortgage back, right? So but mortgage companies don't lend 100% loan to value. So let's say you've got £1 million of property and £700,000 of mortgage. Well, there's £300,000 that is your beneficial interest. That's your portion of owned asset. That's what we put into the trust. So that way, that doesn't fall victim to care fees, litigation, bankruptcy, external threats. Basically, we can protect all that. That's the answer.
Sorry, just on this question. So basically, if it's my properties and I bought it, but someone else gifted me the money, and that person's claiming that person, but actually I legally bought the properties, but the person's claiming afterwards that he put my property into the trust, but he didn't have any legal rights to do that. Can he do that, the person?
Well, so once again, people can sue people all they want. We can't stop people from doing stuff like that. There's freedom to litigate. That's not a problem. Our goal is to stop them from winning. So, we can't stop people you can't stop people from doing stuff. They're going to do stuff. If they want to sue you, they can sue you. That's unfortunately the way the world works, but we can absolutely stop them from winning.
So I think Mike, Mandeep, correct me if I'm wrong, if I've understood. So basically the person gave you the money, but he has put your property in his trust, right?
So it's a family gifted us money.
Yes.
And we legally bought the properties from the person.
Yeah.
But then later on, they went in the court and saying, well, we gifted you money and I put your property into trust, but actually we bought the properties and it's legally owned by us.
Yes.
And he's trying to claim the gift back with the equity. And obviously we've done the work on the property. We've done the extensions, the equities had gone up. So he's trying to claim the equity plus the interest into the property. But it was actually a gift given to us while on our marriage. Yeah. And and we've legally taken over the properties by the banks and everything.
So now for the record, I don't do contention. I'm not a contentious trust lawyer.
Yeah.
But I kid you not, this morning I had coffee with Mark Averill, and if you want, I will introduce you to him, because this is his core competency.
This is really not the right place for us to be discussing personal matters, Mandeep.
If you want to drop me an email, I'll introduce you and be able to answer because he deals in contention. That is really, he loves that stuff. He loves into contentious issues.
And also, can the trustee change the terms of the trusts?
It depends. It depends on whether they have the power to do so. So we generally include all the express powers when we settle a trust in a non-contentious scenario, but we can also delimit the express powers. So you can remove certain empowerments it really depends on what was written into that trust document. It would be a matter of having a look at that.
Sure. Thank you.
Thank you.
No
Linda.
problem.
Shaza, you want to ask your question? Please unmute yourself.
Hi. Hi. Yes. So my parents have a property that was their primary residence, and they want to sign it over to me. But because of the capital gains, my suggestion was to sell the property, buy another one, and then put that into a business, which can then be passed on to me and then down to my children and so forth. Is that a possibility?
Yeah, the disposal will trigger the capital gains event. So when they sell the property, they're still going to have to pay the capital gain.
Okay.
So is it your intention to live in that property? Are you going to be living there?
It's a possibility that I can live in it, but ideally I wanted to, with the sale of that property, I'd be able to buy 2 separate properties, which I was hoping to continue to rent out and then pass on to my children who could live in it if and when they needed it, or continue to live off the rental income of it. So, because currently my parents use that property as the income as a supplement to their pension. So I didn't want them to lose the rental income by handing it over to me now during their lifetime.
Well, remember, if your parents were to place it into trust and give you the asset inside a trust, we can defer the payment of the capital gain for up to 125 years, which is pretty good. And then they can still receive. Now, here's the crazy bit. This is where you get sophisticated. Your parents can still receive the income. It's just that you pay the income tax through your self-assessment, not your parents.
Right.
Where they no longer discharge the income. Remember, undeclared income is criminal. Please don't do that. Somebody declare the income, pay the income tax. And so what we found is, it's a Section 21 gift. You can do a gift back to your parents of as long as the kids are discharging the income, or grandkids, or anybody for that matter. HMRC isn't partial; they just care that somebody's declaring the income. Then they can gift it back to grandma and grandpa, and your parents still receive the benefits that they kind of need to get through.
Right.
If you then, but you will still pay capital gain when you sell the property in the future, right? Because that's an unavoidable event. And then if you sell that property, turn it into 2 more buy-to-lets. Yes, if you bought those buy-to-lets within a limited company framework, that's not a bad move, respectfully, because there's no stamp duty. If you try to jam a property into a limited company, you pay stamp duty. Everybody knows that. But if you're buying it through a limited company, there's no stamp duty. It doesn't create an extra level of SDLT.
But I mean, I wanted the flexibility so that if wherever my children go off to, because like yourself, I've got one in college, one at university, and one in sixth form. So when they need to have somewhere to live, and also my situation going forward, if I end up separate, I'm currently separated. So if I'm divorced, I need somewhere else to live. So I need that flexibility of having access to it, or having an income separate from what I have.
Sorry to interrupt. I think I think if you drop an email to Mike, I think maybe you can jump on a call and discuss in more detail, because this is a bit of because there's a lot of factors that needs to be considered over here.
Yeah.
So just mindful of the time, because there's quite a few other people who are got a query as well.
Yeah. Oh, absolutely.
Yeah, we need to keep these questions kind of short and sweet, and not get in too much personal detail, because like Varun said right at the start, each family has their own complexities, and the estate planning solution that we will be tailoring for you will be specifically for your family needs. So this webinar is more designed to go over the overall effectiveness of trust and what it is that you can do with it, if that makes sense.
Raj, Yunus.
Yeah, hi. Thanks, Arun. So if you have a buy-to-let property in your limited company, do you need to still put it into trust, or you just keep it in a company, so that for your next generation, you just change the directors and then they can own these and you run them?
It's a great question. If you have one property in a buy-to-let company, of course, it's the shares now that own the value. So the shares are inside of your estate. So for inheritance tax purposes, this is still a taxable event when you die, right? That's going to be part of your estate for inheritance tax calculations. What we do with clients who have company-owned property, which is normal, is we suggest that you bifurcate the shares, meaning split them up into A, B, and C or D or whatever you want. And then we absolutely put the growth shares within a trust framework. So that way the growth happens outside of the estate in the future. And then if you start to take dividends against this, you can also diminish the freezer shares. You can actually diminish the value over time. It really is a math equation. It comes down to, is this just one buy to let? Is this 25 buy to lets? What are we discussing, sort of thing? But the answer to your question is, you should consider to put some of the shares into a trust, because then you can reduce the inheritance tax footprint of the estate overall. That's the answer.
Thank you.
Cool. Bessel?
Okay, I wanted to find out whether I've got one property here and I've got a buy to let one property. If I was to sort of sell that both and move abroad, how many years do I have to stay abroad to come before I come back?
Well, that's a good question. So what is the current non-dom scenario? To be honest, I don't know. That's not something, because I only deal in onshore property and onshore trusts. So let me get this straight. You've got two properties, you sell both, and then you go live abroad, and you want to know, the short answer is that's outside of my remit. That's not something I normally deal with, because I only deal with onshore problems. But I can Google it. It says 15 to 20 years on Google. Any questions about 15 to 20 years?
As long as that. Okay, if it's not in your sort of.
Sorry, I can't be of more help, but that's outside of the again, my advice ends at the shoreline.
Okay, thanks.
Cool.
No problem.
Thank you. Hazi?
Hi, sorry, I'm going to try and keep this generic because I think everyone's got very specific scenarios and everyone is different.
Yeah.
And I don't think that's particularly helpful because, you know, I think for something like this, and we've fallen foul of this, if our legal advisors or estate planners, our financial advisors and our accountant are not aligned,
Yeah.
you've got a nightmare. And we've had this issue where we had a property that a buy to let that we sold. Accountant offered us one advice, then we got our investments grew, so we had this unexpected CGT bill which pushed us into the next tax bracket.
Yeah.
And for me, the most important thing for anybody is to ensure that all those three organizations work together. And if they don't, you're creating a massive problem. And it's not, you know, it's if you are not organized and you can't coordinate between those three specialist advisors, you're going to create yourself a massive mess. So my question is, how do you ensure that? For me, I have very good relationships with all our advisors, and for me, I want to ensure that whoever I work with works with all the experts that I've chosen. Because if they don't, if I've missed something, I could end up in a whole world of pain that I have to sort out.
Yeah. No, that's an excellent point, Hazi, sincerely. What I like to say during meetings, I say, butcher, baker, candlestick maker, to use the childhood nursery rhyme. And that is, there is no one advisor that in this complex modern era that's going to just do the whole show. You're going to need a good estate lawyer, you're going to need a good accountant, and you're going to need a good financial advisor. And you're going to need the three of them to be able to communicate amongst each other, because a financial advisor's view on how to resolve inheritance taxes is sell you more life insurance. And I'm not diminishing that as a solution. There absolutely is a need for life insurance. By the record, I don't sell life insurance. But why not make that just the 7 years of the taper? So you could have a declining term insurance, save you a little bit of extra money, and just cover off the 7-year taper if we do the tax planning. But then trying to get these three guys into the room, you've probably heard this before. It's very hard to get somebody to see something when they're being paid not to see it. Right? If this person makes their livelihood by selling a thing, and then you're saying, well, you don't really need to do that thing, then you're going to run into some friction. And so as long as the folks that you're employing are somewhat enlightened and meaning that, and we all have heard this, it's just really tough because, and I mean this transparently, put the client's interests first always. For me, that's generally easier. Sincerely, not because I'm a saint. It's because the type of work that I do is one and done. Like once I've done the job that you've employed me to do, I'm not going to need to redo it again. But then your accountant's going to be there to continue with your filings. Your financial advisor is going to be there for your annual reviews, all that jazz. You're probably going to speak to me again in 3 to 5 years after one of the kids grows up, or maybe something bad happens, or maybe something good happens, whatever that is. But I'm not there every day, every month, every week. So make sure that your advisors actually have some appreciation for the scope of services that the other 1 or 2 do, and then you can avoid everybody giving each other stink eye. And because as you know, it's tough. You know, I've often gone in meetings with financial advisors, and financial advisors are fantastic people. They've worked very hard to get where they are, but then they look somewhat down on what I do because, well, that's fine. You do you, man. That's cool.
Yeah, I mean, to add to that, for example, when we've gone to our financial advisors, because we have a trusted relationship about estate planning, it's generally the standard stuff, you know, gifting, give away, spend it, you know, buy first class tickets, airline tickets. But at the end of the day, you don't know what's around the corner. And so it just doesn't, you know, at the end of the day, you have a big issue that you're going to leave behind after just going through probate for my father's estate.
Yeah.
That was an accepted estate. So we didn't have to fill in very complex, like the IHT 400 form.
Oh, good. You missed that.
But that alone was a nightmare. So what we don't want to do is leave a nightmare behind for our children. And so part of our planning is going to be, if we did, what does the IHT 400 form look like?
Yeah, all 90 plus pages.
Correct.
If anybody ever has a problem sleeping, I invite you to download the IHT 400 form and start reading that. You'll be out like a light within 20 minutes. There's no way. No, it's a very good point, Hazy, and that is when you are bringing in a new advisor who specializes in X, of course, you don't want everybody else just to freeze up. I'm not going to do your self-assessments. I'm not going to do your VAT returns. I'm not going to sell you life insurance or a unit trust. That's not what I do. I don't do any of that. I deal in a very narrow niche, specifically around bricks and mortar. For the most part, I don't provide financial services advice. And if you want to bring any of your advisors on the call and you want them to pepper me full of questions, I'm pretty good at answering them. And when I run out of gas, I'm delighted to report, I've even had a phone call from him this morning. Dr. Paul will take my call all day long. I've worked with him for 10 years. So that guy speaks 12 languages. Like, you're just not going to beat him on knowledge. He's just brilliant. So we're pretty confident in our capabilities on this side. So yeah, we're comfortable. And if it turns out that advisor doesn't like what we're offering or saying, then that's then up to the owner of the assets to make those decisions. That's cool.
Yeah. Absolutely. So like to add into that, like Hazy, is like, I think responsibility of as a owner that we need to make sure that whoever advisor we are choosing, we speak to them these things, that do they work with other advisors as well, how they work with that. And if they can't work with other advisors, then obviously they might not be the right person. So this goes to like what Servan also mentioned as well, that when you're choosing them, like make sure that, you know, like you ask these questions like upfront, and that will save you a lot of pain later on as well. And they might not be like, and the tendency tends to see happen that, if they're not like cost effective as like low on cost, we tend to go for that, but that might not be effective in a longer term. That might be a very costly in the longer term. So yes, next, Andrew.
Oh, it's 1 o'clock now.
Yep. Just quick one, a few more questions. And
I think Mike has a meeting.
I've got 2 clients back to back. Hold on, let me see. Can you get a hold of my client at 1 o'clock?
Yeah, I'll call him now. I'll call him. No problem. Yeah.
Yep.
I will.
Andrew.
Hi, can you hear me?
Yes, we can.
Hello to you, Mike. I found the information very, very informative. So thank you. And your YouTube channel, just super fantastic. Not that any case is simple. However, I think a generic personal circumstance might be simple. If I take my wife and myself, we're a married couple. We have 2 children, direct descendants. And what we would like to do is still live in our main residence. However, should the unfortunate event of death come knocking on the door, we would like to, of course, ensure that our home and the assets that are within that home are passed on to our two children, direct descendants, in such a manner that it is most tax efficient, and of course the inheritance tax. However, the one thing that was niggling me, if I can put it that way, is that I had heard from some estate planner or some advisor somewhere where they said that HMRC could quite possibly still pursue you for inheritance pre-tax the minute they notice that your trust is registered with HMRC. It might trigger them to come after you to go, hey, why are you having a trust? And why are you trying to evade inheritance tax? What are the legalities around that, if I could ask? And again, as I think you said, everyone and anyone can come after you, but I think what I'm asking here is the trust sound, in that if you do put your home, your main residence that you're still residing in a trust, in this case, I take it would be a lifetime discretionary trust is most applicable, yeah? And then left that for our children so that they inherit that without this fear, let's put it that way, of the inheritance tax and of course the care fees.
Right. Okay. So the question is, to restate this, is how can you feel some confidence that that when you settle a trust, whether it's with us or anyone, that this can actually protect you from come what may, be it care or taxes or other things? It's kind of a broad question, but is that the gist of it? Have I got this right?
Yes, it's just that putting our home main residence in a trust for our children's for inheritance tax purposes and care fees purposes, but to make sure that our home, our main residence, is protected.
Sure.
That they will inherit this safely and soundly. However, once I've reached out to you, and I've spoken with Charlie on your team on this before,
Oh, good.
is that once we proceed with this and go, okay, great, we've put our home in a trust and we have the powers of attorney in place and we're all good. The minute you register that trust with HMRC, what is the chance of HMRC come knocking on our door going, aha, we noticed that you, Andrew, had set up a trust. However, we'd like to perhaps pre-tax you in the context of unrealized gains or something like that.
Okay, so the answer to that I think I got this. So the concern is over the new trust registration service that became law here in September 22. And so all trusts, for those on the call, need to be registered with HMRC through the TRS. And naturally, like everybody else here, I'm also prone to thinking that they're not doing it just out of the goodness of they're trying to figure out who to come after. Well, number one, there is no inheritance tax while you still live and breathe. So you don't have to have any anxiety while you're alive. This is a post-death problem. And so the concern then is, how do we know that the planning is going to work as far as taxes go? Because we can get into the fanciful, and I mildly think I heard, well, they're going to try and pre-tax it. Well, there's no legislation in place for that, and good luck, man. I think you'll get armed people up in the streets if they want to come after your inheritance tax before you're in the ground. But it's a fantasy idea, which is really wow. And I'm not diminishing it as a concept, but yeah, there's nothing out there in law or even speculation or any of the committees, nothing. IHT presently is a post-death event, so you won't know about it. Let's do this. I'll do a real quick physical metaphor as to how trusts work. Let's say this red pen, if you can see on my screen, is your house, and your house is worth 1.5 million for easy math's sake, because that's when we know we have an inheritance tax problem. You're a married couple, you've got 2 kids, and you have a house worth 1.5 million. Easy scenario, right? Well, that means you have a 200,000 pound tax bill because you and your spouse should be leaving the house to the kids, presumptively. Therefore, you should be getting £1 million worth of inheritance tax relief. Everybody kind of knows that. So that 500,000 above the million is going to get taxed at 200,000. So how do we do that? How do we protect that? And the answer is simple. We're going to take a trust, which is called a discretionary settlement, and we're going to put that house into a trust. Very simple, like this. Okay? House is in a trust. Now you own this like this. But now you and your spouse can be trustees. You're still in full control of this thing. But when the bad stuff comes, you go, what house? I don't know a house. Because technically you don't. Now, for tax purposes, this is still a GROB or a gift with reservation of benefit. But good news there, or coming back around to the tax solution, is if your children actually are physically living with you still, maybe they're 18 or 19, you could give half of the house to them, but you're never going to give a 750,000 pounds of value to an 18-year-old. Good Lord. That's the definition of completely insane. So we're going to tell you to make sure that you give it to them. Guess what? Shrink wrapped in a trust. So now that 750 arrives in with the kids. Mom and dad can still remain in full control of that thing. And 7 years later, that 750 is now going to be outside of the estate for inheritance tax planning. Now your 1.5 main res is worth 750 on paper. And you've got two different trusts, one for mom, like you probably got 4 trusts here, one for mom, one for dad, one for daughter, one for son. Either way, they can't come after a thing that you don't own. They can't go after taxes. So let's say then mom and dad died more than 7 years after this strategy was built. Where's the money? Well, the money's in trust, put in lifetime a decade earlier, say. They can't tax. I can't tax your estate, Andrew, for the Eiffel Tower. You don't own it, right? It's just, that's not a thing. So we put together frameworks that literally get the assets outside of your estate. Now, the final thought is, but I still live in the house. Yeah, ain't that great? In fact, one of the problems in inheritance tax planning is the main residence, which is often the largest single asset. How do we get that outside the estate for inheritance tax purposes, all the while mom and dad continue to live in it? Right? That's the key, because otherwise it'd be a gift with reservation of benefit. And the answer is there's a piece of planning from 1999. It's mainstream, pure vanilla stuff if you're in the industry. And that's what we do. We will, and be happy to do that for you, happy to walk you through it. I'll even give you the 4 test questions. The 4 test questions are simple. And the 4 test questions go to 0 if the kids live inside the house. And the 4 test questions are, do the kids come by to visit more often than Easter and Christmas? Do they come by with some frequency? Do they have a key to the property? They know where the secret key is? Do they know the passcode? Can they come and go as they please? They have freedom to move in and out of the property. Do they keep any of their personal effects in the property? And do they pay less than 50% of the utilities and council tax in relation to the property? And most kids pay nothing. If the answer to all the above is yes, then we can qualify this gift. That's not a problem. So now we've solved for the inheritance tax on this made up 1.5 million pound main res. It does take 7 years. So as I like to jokingly say to clients, eat more broccoli and look both ways. But yeah, the final line there, they can't come after stuff you don't own, Andrew. Does that help?
Sorry, do all the trusts have to be registered with the HMRC land registry? How do they get validated?
So trusts are registered with the Trust Reservation Service within HMRC. You're going to need your UTR number or your unique tax reference payer number, and you can just register the trust.
Cool. Dave?
Thank you.
Dave, you still around? Okay. Next.
Yes, I am.
Yes.
Sorry about that. I was having some issues.
No worries. Please go ahead.
Yeah. So, quick question. My question is, we are currently in the process of buying a flat for my disabled nephew. A flat with a mortgage. Should we wait to put the flat in a trust after we buy it for him, or should we do it now?
Is the child over 18?
Yes.
And how many second properties do you own?
You mean myself?
Well, are we talking about 50 properties, 1 property? How many other properties? It's more about the global estate value. So you're asking a specific question, and I'm happy to buzz through this real quick. Is the estate more than 5 million pounds in gross value? Is the estate is this your first secondary property? And then what is the value of the secondary property? So this flat you're buying, is it over 650 in value, or is it under 650 in value?
Yes, under 650, and it's we don't own any properties, but we're just helping. Basically, we just, as a family, we're helping my nephew get on the property ladder to try to be more independent. So we don't own any properties. It would just be his primary residence, and it's less, and it's 200,000 K.
So the thank you for that, and thank you for sharing. The concept here is you may not need a trust. And this is strange from a guy that sells trust profession for a living. I'm not here to sell you stuff, just to sell stuff. I'm well past that. That's not what we do here. You might just need to register a charge on the property to secure your interest, if that is what in fact you want to do. But it would be the person purchasing the property that should consider to put it into a trust or protect it against external threats. They'll come what may, because it's coming. Sorry, it's not a may, it's definitely coming. It's just when, right? But if you're lending monies to a family member, that may not be a trust event for you. That may be more a situation where you just place a charge on the property, a second charge maybe. Or we can do a declaration of trust. Like there's about 2 to 3 different ways, and it all has to be specific and for your family's situation. So there's lots of different ways to do this is the answer. And it just really boils down to what's the most tax, cost, and time efficient to get that done for you.
Sure. But would you recommend we do it before or after we buy the property? Apologies for not being clear.
Thank you. You can always set up a trust and not own a property. That's called a pilot trust. What you're doing is you're just setting up a trust, and the only thing in it is 10 pounds, right? And then it sits there ready and able to take the property. So if you know you're going to buy a property, you can always settle a pilot trust, and we can populate or we convey in the property once you've got it purchased. And it sounds like a South Asian family, and South Asian families, my wife's from Southeast Asia, pull together, and you may not even have a mortgage because the family will just pull money together, which is smart. In that case, then you can put legal title into the trust and probably have, maybe you want to have an interest in this, maybe not, probably a better question for offline. But again, there's about 3 to 4 different possible solutions here, depending on what you want to achieve.
No, thank you very much, Mike.
Cool. We've got time for one more question. So Alamail, like if I pronounced correctly, sorry about that. Like, yeah, can you please unmute and ask your question?
Can you hear me?
Yes, we can.
Oh yeah.
Thank you. A quick question. I think I have been listening to this for a while, but my question is not unique. What I wanted to just see, creating a trust. How easy is it to draw money out for the children in the future? Now, my children are adults now, but I have a property company. I don't have a primary residence here. I've left my primary residence. I kind of spent time abroad quite a bit. But if I created a trust, I mean, it's been in my thoughts for a while. I'm just thinking, how is that going to make it easier for the children to access the funds? What happens?
So the short answer is it's easy to get money out of a trust if it is the kids that are the actual trustees, and we always recommend it's family members in the first instance. We would the second question is this money that is in cash, or is it money in bricks and mortar? Because it's hard to turn bricks and mortar into cash, obviously, unless you dispose of a property or refinance.
Yeah.
Right? But that's not the question. The question was how easy to get cash out of a trust, and the answer is as easy as the trustees want. So you presumptively have cash in a bank account. The bank account's attached to the trust, no problem. They go down to the bank and they take the money out.
Oh, okay. So it's not money, not in terms of money, but maybe in shares and properties. Basically, I'm thinking the property company will become a trust. That was my initial question.
That's as complex as the state of value. Remember, a trust doesn't own a property. A trust owns value. So you could have
value.
You could have a boat. You could have a boat. What is the form of value? Is it a property? Well, then we put the HMLR records into the trust, and now that is deemed to be the owner of the asset. But maybe you sell that property and buy a plane. Okay, then we can put the tail number for the plane into the trust. Like planes can hold, a trust can hold value. And so the question is, how difficult is it to turn it cash? Well, it depends on what that state of value is. Is it cash? That's easy. Is it property? I think you're going to have to sell it.
Yes.
That's really it has nothing. Actually, it's not about trust per se, because trusts don't create friction unduly. It's more about the state of the asset, state of the value.
Well, yeah, because as somebody Andrew pointed out, it will trigger HMRC. If that's the case, you got to think of the, the sort of
Yes,
situations.
don't worry, HMRC is always waiting to get more tax. They're always,
Exactly.
That's their job.
HMRC is right there. They're very keen to get their taxes.
Yeah.
Yeah, and I find talking to a lawyer, I have an accountant who's also a property owner, a multiple property owner, but actually, property owning accountants don't necessarily have all the information, and solicitors don't have information of company property.
Thank you. You've hit my niche. Now you understand why I exist.
Yes.
I'll give it to you like this. Accountants do not know the law in the main.
Yeah.
Solicitors under SRA guidelines are not allowed to give tax advice.
Yeah.
Now you've discovered the niche I exist in. I exist right in the niche between your accountant and your solicitor. So that's literally so I'm not very wide. I don't deal with intellectual property rights. I don't deal with divorces. I don't do insolvency. There's a lot of law I don't cover. But just like if you went to the NHS you wouldn't go in to see your doctor and with a toothache, you would go to a dentist. You've got to find the right specialist for what you actually need. And so that's why I always start every client engagement off with what is the problem you're trying to solve? Because if I'm not your guy, we'll figure this out in the next 5 minutes. I definitely can direct you to somebody that can deal with this. I've been very fortunate over the last several years.
Yeah. And to be honest, like for everyone, that trust is something which is it is a very unheard of as well. Like people have just heard the name, but they don't know how they work, how easy it is. And it just that's where the mic comes in, which he makes it really easy to you to understand as well, and execute in a proper way for a longer term. Because yes, I've come across many people who just think about right now and then just do it just to make get their fees. That's it. But it's very important to choose your advisors very carefully as well, because they're thinking from the future as well. And that's why it's very important to discuss every single scenario, what's happening in your life with the trust planner as well, which is a very important key point.
Yeah, when I completed my will recently, my solicitor said there's no need to take any details of the company if you just make it in the will that everything goes to the 2 children I have. That's straightforward. However, I wasn't really happy with that.
He's going to dodge the tax advice because he's not. And here's the last thought on this. I work in the knowledge business. So when people are selling knowledge professionally, no one wants to look like a dum-dum. And I understand that. And I can speak about this without my ego getting in the way, because I've got a doctor of law. I am nowhere near as smart as Dr. Paul. I'm not even joking. I'm just charming, or try to be. And after over a decade of doing this, I've got my 10,000 hours. The point I'm getting at is your solicitor's never going to say to you, I don't know the answer to that, because he sells knowledge and he needs your respect. And I respect that. That's cool. He's a normal person. And your accountant's not going to tell you, I don't understand the law around that. So what they're going to do is they're saying, oh, it's really difficult. And often what you'll hear from solicitors is, you should go talk to your accountant about that. And from your accountant, you hear, you should go speak to a solicitor. And that's where you need to find a guy like me. This is literally the niche I exist in. That's it. That's all I do.
Thank you, Mike.
I hope
Thank you.
That's really, really helpful, Mike. And thank you everyone for attending today. And I'm going to have to cut this short because Mike does have a client meeting. And I know you guys all have so many questions. Feel free to email us. We're more than happy to have a conversation off the record. And yeah, you will receive a recording from everything. Thanks. Thank you so much.
Yeah, thank you.
Thank you, Varun.
Thanks, everyone. Thank you. Thanks, Mike.
Thanks all. Thanks,
Thank you.
Thank you.
Bye, guys.
Bye.
Thanks, Mike. Thanks, everyone.
Thank you, Mike. Thank you all.
Thanks, guys. Bye.